Good morning, afternoon, or evening. Welcome to All Things Social Security. I am Stephanie Joy, the attorney at Joy Disability. Welcome to the channel, and I hope you enjoy the video. Have a great day. Bye-bye. Good morning, afternoon, or evening. I wanted to share with you some lingo from a recent fully favorable remote DLI award I just received for one of my beloved clients. And the striking part about this is that in all of these awards, in this case, it's point number 5. And I don't know that they're always the same. When I say point number 5, I mean it's like the 5th major paragraph. It's bolded out. They go through all the sequential evaluation process points primarily, but not sometimes there's some additionals in there, depending on what little issues crop up that might be like little sub issues. But in this case, there are none. First, did I mention it was a 3-page decision for a fully favorable award with a remote onset date going back to before COVID. So this is really awesome, but I want to get to what was beautiful about it, aside from the fact that it's a fully favorable, which are my favorite. Under the RFC paragraph, which I said in this case is number 5, the judge assigned the claimant a light exertional. Now, assigning a light exertional would deny a person between 50 and 54 of meeting the grids because you have to be less than light. You have to be sedentary or less. At the time of this alleged onset date, the claimant was indeed under 55. However, he still fully granted her back to when she was under 55, despite finding her to have a light RFC, exertional capacity, because she would be off task for 20% of the workday or would miss more than 3 days of work per month. And during our hearing, the judge had specifically asked, and if he hadn't, I would have, because that's just what we do. He specifically asked the vocational expert if a hypothetical person of the same age, education, and experience as the claimant were to be so impaired as to be off task, despite being strong enough to do light work, but would be off task for 20% of the workday, would that person be able to perform any job successfully within the customary tolerances of the employer, any employer? And the vocational expert said no. And then similarly, the judge had asked about absenteeism. And I forget the amount. He might have said 2 or more days or more than 1 day. And the VE said there would be no jobs that that hypothetical person can do. At that time, one of our finger crossing was that the judge would indeed find that the claimant, our claimant, my client, would be off task 20% or more. Sometimes it's even 15 will work for you. But so keep in mind, finding that someone will be off task is something that is not usually the way they will award. We always put it in there because you can have beautiful results like this. But and that was specifically in my brief and pointing to evidence that would suggest the person would be off task, things from the medical records. But that is not usually how they do it. It is kind of like a catch-all. So if the judge wants to award because he thinks the person is and was disabled, this is one of those discretionary type of things you can kind of read between the lines and use. And they usually don't. But here's an example of where they did, which was stunning, because he didn't even have to give her a fully favorable, which means going back to the onset date we asked for, which was way before her very remote DLI. I mean, her DLI just a year or 2 ago, and he awarded back to before COVID. So that it's not going to give her more back benefits, because if an application didn't go into 2024, she can only get paid back to 2023, even though she was, to say, disabled back in 2018, and provably so, because of that limit on retroactive payments. So this is where it's important. This person didn't even know that she could apply for disability. A lot of people are unaware of Social Security disability. I mean, they're becoming more aware, ever since I suppose we have the internet and all that, but a lot of people aren't aware. And also a lot of people, and I think this one included, do not want to file because they're optimistic, naively or otherwise, that they're going to improve enough to go back to work. And a lot of people, actually, I shouldn't even say naively, a lot of people do improve enough to go back to work. So they might be out of work for a year or two. They could have filed actually for a closed period, but they didn't, and they went back to work and everything's fine and kosher. I really commend those people, actually, not because they didn't file for at least a year worth of benefits when they could have, but that also kind of runs, I don't know if it's like a psychological thing, but sometimes when people start disability payments, the mindset changes. Maybe someone has less optimism of improving. It could just be a psychological effect. So by not applying, I think some actually do recover enough to go back to work, at least for a certain amount of years. And by then, perhaps they're in a new age bracket. They get a new, more favorable laws applied to them due to the medical vocational guidelines, etc. There can be a ton of reasons, or a ton of positive output. So when they do eventually find they can't do their current job, that might be enough with everything else to apply the rules that would not have applied to them before. But anyway, going back to it, an example of a light RFC that you wouldn't expect to win for the person, but because the judge grabbed onto the 20% off task, 20% of the workday, the person would be off task. And by the way, that can be mental reasons, pain reasons, or a combination of the two. So he does go in and give a bunch of details, but I don't think it's really necessary, specific ones to the particular impairments, but really not necessary. Just wanted to drive home the fact that off task, if between the lines, well sprinkled throughout the historical, durational, multi-year record set, can apparently do the trick. And the way you can get that in there, because a doctor's not really going to speak to that like that, but one way you can help ensure, and it's funny because you're doing it back at a time when you don't even realize what it might be for, and it's certainly not something that's going to make off task at the time you do it. It's the accumulation over time. If there are comments, complaints in the medical record consistently for years to your doctors, one or more or all, that you are brain fogged half the days, or the pain gets so bad I can't even focus and I just cry. Or, I mean, I'm giving you examples, but whatever fits you, if this happens to be one of your symptoms that you just got to go and recluse yourself in your room to get refocused again, mitigate pain, etc., etc. You could point to those things. None of them say 20% off task for a workday, but you could point to them and say, here, the record is abundant with descriptions of what would be off task time that was occurring all throughout, the 3 years before this hearing or whatever. Just something to think about when you're preparing your case. It worked out perfectly here. This was one of those, by the way, I would say this was a 5%er. It wasn't really a 1%er, but it was a 5%er. And that was because of the extremely distant remote DLI. Well, I shouldn't say it was extremely. Maybe it was a 10%er. It was any remote DLI actually probably knocks you down to 5% because, and I'm going to reiterate this, when someone has a remote DLI, which means your date last insured for your SSD insurance expired already because it is term insurance and you stop paying in when you stopped working. If that is the case, any recommendation I give you, and I'm the nag, my clients will all agree, treat for this, even though you don't think it's your big problem. Because that current treatment they can still do, and it'll still be included in their entirety of an evidence to find that the person is disabled. Doing it now on someone with a remote DLI does not affect the evidence from the period that has to be used to find whether or not they were disabled at that time. Current evidence can't do that. Only evidence from that era can do that. So that's the difficulty with the remote DLI. They can't utilize that legal recommendation set of how to grow their evidence today. And it's why things are a low percent, like one of my 1%ers or my 5%ers. But it also means getting an attorney. Yeah, they can still work up the case, work up the brief, gather the medical records, turn it into a fantastic argument, like apparently we did. But we can't do that other half of the job, which I think is really important, which is what gets us a lot of wins on initial and recon, and certainly at ALJ. Do this now. It'll be part of your evidence set because your DLI is in the future. You still have insured status. You're still in your window. All right? All right, guys, that's it. Awesome win. I am so excited for my gal, and she should have a nice chunk of change coming her way. All right, I'll talk to you guys later. Bye. If I can figure out how to turn this off, of course, as usual. They change it up all the time.